Thank you for visiting my channel. Before we start, please hit the subscribe button so you'll be notified of future presentations. This is a brief presentation of sections 11 to 17 of the Negotiable Instruments Law. The discussion here is lifted from my book, The Law on Negotiable Instruments. Section 11, Date Presumption as to. Where the instrument or an acceptance or any endorsement thereon is dated, such date is deemed prima facie to be the true date of the making, drawing, acceptance, or endorsement, as the case may be. This provision applies to three situations. 1. The instrument, either promissory note or bill of exchange, contains the date of issue. 2. In an accepted bill of exchange, the acceptance is dated. And 3. An instrument is endorsed and the endorsement is dated. Under Section 6, date is not essential to the validity or negotiability of an instrument, but where the instrument or an acceptance or an endorsement thereon is dated, such date is deemed prima facie to be the date of the making, drawing, acceptance, or endorsement, as the case may be. Though the date written on a negotiable instrument is often important, it should be borne in mind that the instrument takes effect not on the day written as the date of the making or drawing, but on the day the instrument is delivered to the holder. Section 12. Ante-dated and post-dated. The instrument is not invalid for the reason only that it is antedated or post-dated, provided this is not done for an illegal or fraudulent purpose. The person to whom an instrument so dated is delivered acquires the title thereto as of the date of delivery. An instrument is antedated when the date written thereon is earlier than the true date of its issuance. For example, the actual making or drawing is on June 1, 2021, but the date written on the instrument is May 1, 2021. That is antedating. Meanwhile, an instrument is post-dated when the date written thereon is later than the true date of its issuance or delivery. For example, the actual making or drawing is on June 1, 2021, but the maker or drawer states July 1, 2021 on the instrument. That is post-dating. An antedated or post-dated instrument is not rendered invalid or non-negotiable by that fact alone. It may be negotiable before or after the date given as long as it is not negotiated after its maturity. Does antedating or post-dating invalidate an instrument? Yes, in one situation where it is done for an illegal or fraudulent purpose, like to avoid payment of interest. What is then the effect of antedating or postdating an instrument for an illegal or fraudulent purpose? Although this section is silent on the matter, the implication is that it invalidates the instrument, but such invalidity may not be set up against a holder in due course. Under this section, the person to whom the instrument is delivered acquires title or ownership over it not as of the date written on the instrument, but as of the date of actual delivery. Section 13. When date may be inserted. Where an instrument expressed to be payable at a fixed period after date is issued undated, or where the acceptance of an instrument payable at a fixed period after sight is undated, any holder may insert therein the true date of issue or acceptance, and the instrument shall be payable accordingly. The insertion of a wrong date does not avoid the instrument in the hands of a subsequent holder in due course, but as to him, the date so inserted is to be regarded as the true date. Under Section 6, the date is not necessary for the negotiability of the instrument. However, the date may be necessary to determine the date of maturity. In the following cases, the date is also necessary. 1. Where interest is stipulated to determine when interest is to run, and 2. To determine whether a party has acted within a reasonable time. What is the effect of the insertion of a wrong date? Knowingly inserting the wrong date in an undated instrument will avoid it, as to the party so inserting the wrong date. It is implied in this section that the insertion makes the instrument void as to him who, having knowledge of the true date, made the wrong insertion. However, the insertion of a wrong date does not avoid the instrument in the hands of a subsequent holder in due course. As to him, the date so inserted will be regarded as the true date. Section 14. Blanks when may be filled. Where the instrument is wanting in any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein. And a signature on a blank paper delivered by the person making the signature in order that the paper may be converted into a negotiable instrument operates as a prima facie authority to fill it up as such for any amount. In order, however, that any such instrument, when completed, may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within a reasonable time. But if any such instrument, after completion, is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up strictly in accordance with the authority given and within a reasonable time. This section pertains to instruments that are incomplete but delivered. There are two steps in the execution of a negotiable instrument, namely, 1. The act of writing the instrument completely and in accordance with Section 1 of the Negotiable Instruments Law, and 2. The delivery of the instrument with the intention of giving effect to it. Where a promissory note or a bill of exchange is executed in blank and delivered to another to fill in and negotiate either for his own benefit or that of the maker, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein. In order, however, that any such instrument, when completed, may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within a reasonable time. But even if it was not filled up strictly in accordance with the authority given, if any such instrument after completion is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up strictly in accordance with the authority given and within a reasonable time. There should be no problem if the instrument was filled up strictly in accordance with the authority given. But suppose it was not filled up strictly in accordance with the authority given. For example, the authority given was for 10,000 pesos, but the person in possession of the incomplete but delivered instrument wrote 100,000 as amount due. The effect is that the instrument is avoided against any person who became a party thereto prior to its completion. However, such irregularity does not affect the rights of a holder in due course. Despite the unauthorized insertion, if such instrument after completion is delivered to a holder in due course, it is presumed to have been filled up strictly in accordance with the authority given and within a reasonable time. Hence, it is presumed valid and effectual for all purposes in his hands. The same rule applies where a blank paper with a signature on it is delivered by the person whose signature appears thereon with the intention to convert it into a negotiable instrument. The law says the person in possession of the blank paper with the signature may fill it up as such for any amount. It is important to note, however, that the blank paper must have been delivered with the intention to convert it into a negotiable instrument. If such intention was not present, like the paper was delivered simply to allow the transferee to familiarize himself with the transferor's signature, or as autograph of a famous person, the presumption of authority to fill it up as such for any amount does not apply. Section 15. Incomplete instrument not delivered. Where an incomplete instrument has not been delivered, it will not, if completed and negotiated without authority, be a valid contract in the hands of any holder as against any person whose signature was placed thereon before delivery. There are two steps in the execution of a negotiable instrument. 1. Writing of the instrument completely in accordance with the requisites of Section 1, and 2. Delivery of the instrument by the maker or drawer to the payee in order to give legal effect thereto. This section refers to instruments that are incomplete and undelivered, meaning the steps above are not complied with. The law says where an incomplete instrument has not been delivered, it will not, if completed and negotiated without authority, be a valid contract in the hands of any holder as against any person whose signature was placed thereon before delivery. Hence, non-delivery of an incomplete instrument is a real defense which may be interposed even against a holder in due course. Under Section 14, a holder in due course can recover despite wrong insertions. Under Section 15, however, even a holder in due course cannot recover from one whose signature was placed thereon before delivery. Can anybody then be held liable on an incomplete and undelivered instrument? Yes, those whose signatures were placed thereon after delivery, namely, the acceptors and indorsers in view of their warranties under Section 62 and 66. Section 62 refers to the liability of the acceptor and 66 liability of general indorser. Section 16, delivery when effectual, when presumed. Every contract on a negotiable instrument is incomplete and revocable until delivery of the instrument for the purpose of giving effect thereto. As between immediate parties and as regards a remote party other than a holder in due course, the delivery, in order to be effectual, must be made either by or under the authority of the party making, drawing, accepting, or endorsing, as the case may be, and in such case the delivery may be shown to have been conditional or for a special purpose only, and not for the purpose of transferring the property in the instrument. But where the instrument is in the hands of a holder in due course, a valid delivery thereof by all parties prior to him so as to make them liable to him is conclusively presumed. And where the instrument is no longer in the possession of a party whose signature appears thereon, a valid and intentional delivery by him is presumed until the contrary is proved. A negotiable instrument is not only a written evidence of a contract, but it is also a specie of property. Just as a deed to a piece of land must be delivered in order to convey title to the grantee, so must a negotiable instrument be delivered to the payee in order to evidence its existence as a binding contract. Thus, the payee of a negotiable instrument acquires no interest with respect thereto until its delivery to him. Delivery of an instrument means transfer of possession, actual or constructive, from one person to another. Without the initial delivery of the instrument from the maker or drawer to the payee, there can be no liability on the instrument. Moreover, such delivery must be intended to give effect to the instrument. This section applies to an instrument that is mechanically complete but undelivered. Before delivery, the maker or drawer can revoke, cancel, or tear up the instrument. The payee named in the instrument acquires no right until the instrument is delivered to him. Under Section 16, the possible defense of a party sought to be charged is that the instrument was not delivered, or if delivered, delivery was not authorized, or only on a condition, or for a special purpose. This defense may be termed want of delivery of a mechanically complete instrument. Such a defense, however, is not available against the holder in due course, because under the law, proof of lack of delivery or of unauthorized delivery or of conditional delivery or of delivery for a special purpose is barred inasmuch as in the hands of a holder in due course, the valid and intentional delivery of a mechanically complete but not delivered instrument is conclusively presumed. Such a defense, however, may be interposed against an immediate party and remote parties not holders in due course because the presumption of valid and intentional delivery is only rebuttable as to immediate parties and to remote parties who are not holders in due course. The defense is therefore only a personal defense. Section 17, construction where instrument is ambiguous. Where the language of the instrument is ambiguous or there are omissions therein, the following rules of construction apply. A. Where the sum payable is expressed in words and also in figures, and there is a discrepancy between the two, the sum denoted by the words is the sum payable. But if the words are ambiguous or uncertain, reference may be had to the figures to fix the amount. B. Where the instrument provides for the payment of interest without specifying the date from which interest is to run, the interest runs from the date of the instrument, and if the instrument is undated, from the issue thereof. C. Where the instrument is not dated, it will be considered to be dated as of the time it was issued. D. Where there is a conflict between the written and printed provisions of the instrument, the written provisions prevail. E. Where the instrument is so ambiguous that there is doubt whether it is a bill or a note, the holder may treat it as either at his election. F. Where a signature is so placed upon the instrument that it is not clear in what capacity the person making the same intended to sign, he is deemed to be an indorser. And G. Where an instrument containing the word "I promise to pay" is signed by two or more persons, they are deemed to be jointly and severally liable thereon. The provisions under this section are mostly self-explanatory, but further clarification may help with respect to some of them. An example of the application of paragraph A is a check containing the figures P365 and the amount written in words is 365 pesos. As a general rule, words prevail over figures, but in this case, the words are ambiguous. They may mean 365 pesos or 3 pesos and 65 centavos, in which case reference may be had to the figures since this is a case of ambiguity in the words used. Paragraph E pertains to an instrument that is so ambiguous that there is doubt whether it is a bill or a note. The law says the holder may treat it as either at his election. However, an instrument in the form of a bill addressed by the drawer to himself may be considered as a promise rather than as an order. This fact is recognized by the rule that where the drawer and drawee are the same person, the holder may treat the instrument at his option, either as a bill of exchange or as a promissory note. The holder of a bill in which the drawee is a fictitious person, or a person not having the capacity to contract, has the same option. A bill drawn by an agent on his principal by authority of the latter is equivalent to a bill drawn by the principal on himself and comes within the rule under this discussion. Paragraph F holds that when it is not clear in what capacity the instrument was signed, the signer shall be deemed as an indorser. This is consistent with the provisions under sections 63 and 64 on irregular or anomalous indorser. However, this rule applies only where there is a doubt as to the capacity of the signer, and the doubt may arise out of the location of his signature on the instrument. Therefore, one who signs in the place for the maker's name or in the place of the drawer's name is not an indorser, and parole evidence is not admissible to show that he intended to be bound only as an indorser, because in that case there is no doubt as to the capacity of the signer. In these cases, there is no doubt in what capacity they sign in view of the location of their signatures on the instrument. It has been held, however, that if the payee signs on the face of the note under the signature of the maker, he is bound as an indorser. The instrument under paragraph G appears self-contradictory, being signed by several persons but beginning with "I promise to pay." The use of the word "I" is thought to indicate an intent that each person shall be severally liable. Each maker of a joint or several note is liable to pay the whole amount, but if one pays more than his share, he can have contributions from the others. If it reads, "We promise to pay," the obligation will be joint, that is, all the parties would have to be joined in an action. An instrument which begins with "I" or "either of us" promise to pay, when signed by two or more persons, makes them solidarily liable. Also, the phrase "joint and several" binds the makers jointly and individually to the payee, so that all may be sued together for its enforcement, or the creditor may select one or more as the object of his suit. That will be all for this presentation. Our reference material is The Law on Negotiable Instruments by yours truly. If you find this presentation helpful, hit the subscribe button so you'll be notified of future presentations. Thank you.